Good evening and welcome to Lawyers on the Line. I'm Eric Beyer, a partner with the Duluth law firm of Falsani, Ballmer, Peterson, Quinn, and Beyer, and this evening's moderator. Tonight's topic is bankruptcy and foreclosures. Even in this recovering economy, it becomes difficult for people to keep up with their financial obligations. This can sometimes have devastating legal repercussions, but it doesn't have to. Here to discuss the issue tonight is tonight's panel, Yvonne Michaud-Novak of the Law Office of Yvonne Michaud-Novak, and Joe Ferguson of the Johnson, Killen, and Seiler Law Firm here in Duluth. Yvonne and Joe will respond to your questions about bankruptcy and foreclosures. Please call us with your questions at 218-788-2844, or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. All right. Joe, why don't we start with you? First of all, I think you have a special birthday announcement.
I do. I promised our office manager, Julie Manella, that I would wish her a happy 49th birthday. It's coming up this month.
Excellent.
Thanks.
Joe had his iPhone here, and he got an important message. He had to make sure that delivery was made. But why don't you tell us a little bit about bankruptcy? Why do we have bankruptcy laws in this country?
Bankruptcy laws in this country were promulgated to avoid the debtors' prisons that the folks who came over on the Mayflower had suffered in England and Europe in general. It became a constitutional right to be able to absolve yourself of financial liability. It was codified in 1898 in the Bankruptcy Act. And what it does is it provides people who honestly get themselves into a financial jam to dissolve their liquid assets and have those paid over to their creditors in exchange for a complete discharge of all of their debt. Okay. And the Bankruptcy Code defines it as a fresh start. That's how we define bankruptcy. It gives people an opportunity to have a fresh start.
Okay, and Yvonne, there are all sorts of different types of bankruptcies as I understand it. Why don't you run through what are the different types of bankruptcies that you deal with?
Chapter 7 is the standard bankruptcy that people think about. It's called a liquidating bankruptcy. Your non-exempt property is sold to pay your debts. A Chapter 13 is a debt repayment plan. A Chapter 11 is for big business, and a Chapter 12 is for farmers and fishermen.
They have their own statute.
Yes, they do.
Excellent. All right. How does a bankruptcy start? Somebody finds themselves in a bind. What do they do next?
Bankruptcies generally start by creditors obtaining a judgment against the debtor. We call the bankrupt individual or debtors, husband and wife, and they start pursuing them based on the judgment. They'll garnish their wages, they will garnish their bank accounts, the credit card companies will start calling them at home, they'll start calling their employer, they'll even call neighbors. And it becomes a very emotional a nightmare for these people, and they will come in and explain what their financial situation is, and we determine if they are eligible for bankruptcy under either Chapter 7 or Chapter 13.
Okay. Yvonne, after you make that determination, what do you do? I mean, you file something with the bankruptcy court, I assume?
What happens is we have people bring in a lot of information. We have to look at what they have for assets, what they have for debts, and then we take all that information, put it into the computer, and get a stack of papers that we go through with the client to make sure that everything's there. We then file that electronically with the court, and about a month later have a meeting with a trustee who reviews that information to make sure all of their assets and debts have been disclosed.
Who's the trustee?
Our local trustee is Bridget Brine.
Okay.
And that person is responsible for making sure that all of the assets have been disclosed and selling off any of the non-protected property.
Okay, all right. Let's get into some specific questions that we've had. Joe, is my retirement account exempt from bankruptcy?
Completely exempt.
Okay, so
under both the federal and the state exemptions, all of your IRAs, 401ks, railroad pension, you name it. If it is a tax-qualified retirement plan, it is totally exempt.
Okay.
Very quickly, the state of Minnesota allows individuals who file bankruptcy to claim either the federal exemptions or the state exemptions. and that is typically driven by the value of equity in your homestead. In Minnesota, if you have a homestead, a husband and wife can exempt, but what is it, about $380,000 now of equity in the homestead.
Okay.
Under the federal exemption, the exemption is much less. It's closer to
46,000.
46,000. So,
All right. Okay, question from a caller in Grand Marais. This is very important these days is with student loans accumulating and the cost of tuition question, students mounting lots of student debts, can they ever get out from under it through bankruptcy?
Unfortunately, under today's laws, it is very difficult to get your student loans discharged.
Okay.
as a general rule, the best you're going to come out with is a modification of the amount owed. But you've essentially got to be 65 or older, on total disability, unemployable, and never, ever able to repay any part of that student loan.
And sometimes people ask me, and at least in the type of work that I do, why is the law this way? And my understanding in bankruptcy is that these are all statutory, and it's about what Congress wanted to pass or exempt or what change or whatever rules they want to make. Is that right? I mean,
Exactly.
and for some reason, they don't think that why is that?
Well, there's a lot of stories out there about lawyers and doctors and people in professions who run up big debts, and then somebody says they filed bankruptcy and got rid of it.
Right.
That's not what I see in my everyday practice.
Right.
And there's a push right now on a national level to be able to get the discharges for people, to get those debts released, because people are coming out of school with debt that's more than what their first house will be.
Right. I remember those days. Yeah.
As a matter of fact, the reason is the policy consideration is this. If you're 21 years old and you go to a bank and you ask them for $150,000 to go to law school, they're going to laugh you out of the bank. So you cannot underwrite a 21-year-old for a $150,000 loan.
Sure.
So the government, in their infinite wisdom, decided to make the debts non-dischargeable so that they could find people who would invest in funding these student loans, and that's why we're in the mess we're in.
So the 21-year-old can make a decision that will affect them financially for the rest of their lives.
That's correct.
Yeah,
That would
all
be
right.
another discussion.
Right. Right. All right. A question. This is having to do with the foreclosure. Can anybody go and buy a property that is up for sale at a foreclosure auction that is publicized by a sheriff's office?
Yes, anybody can go and buy that. However, they have to outbid the foreclosing lender, and they need to, I believe, have cash with them at the time of the sale.
The rule is you've got to outbid the mortgage holder. You got to put 10% cash down and pay the rest in cash within 24 hours.
Okay. So it tends to be people that have their financial house in order do this quite a bit.
As a general rule, what happens is ABC Bank at the foreclosure will bid in the total amount of the mortgage, including the accrued interest and all the costs involved in the foreclosure at the sheriff's sale. You've got to bid $1 higher than that.
Okay.
And at that time, you put down 10% cash, and then within 24 hours, I think it's 24 hours,
Okay.
the other 90% has got to be paid.
Okay.
And then, yeah, anybody can, and the banks love it. The banks would love it. It never happens, but the
Right.
banks would love it.
Right. Because because they're going to get their money back. And that's the whole
Absolutely.
point. Okay.
Absolutely.
All right, question from a caller in South Range. This is a general question. Maybe you can talk about some of the considerations you give people when they're filing for bankruptcy. But she says $50,000 in debt, but only makes $11,000 a year. Should I file for bankruptcy, and is there a minimum charge to file bankruptcy?
Well, you mentioned that the caller's from South Range, and so that first brings up that they're a Wisconsin resident. The rules in Wisconsin are different for what we can protect than the rules in Minnesota. In both states, we're allowed to use the federal exemptions to protect assets.
Okay.
But what determines whether a person needs to file a bankruptcy, the amount of debt is critical, but the structure of their assets, how much equity they have in their home. Do they have toys like ATVs, fishing boats? Are they under subject to garnishment? Are they making a wage that can actually be taken? All of those things are things that we look at when we're determining if somebody should file a bankruptcy.
Okay. And what is the minimum cost for somebody to file a personal bankruptcy?
It varies on the complexity of the bankruptcy, but I think most lawyers in this area charge a minimum of $1,500 for a Chapter 7, and then the filing fee is about $300 on top of that. So
Okay, so we're talking filing fee, which is whatever it is, and
the
then
bankruptcy court is $308.
307.
307, sorry. And then your legal fee, of course.
okay, and then legal fees up to the individual attorney handling the
Correct.
case.
It depends on the complexity,
Sure.
you know, yeah.
Okay. Question from a caller: if I borrowed money from my parents, do I have to list them in the bankruptcy?
You're required to list all of your debts. So yes. Now, with your parents, the debt can be legally discharged. It's up to you if you want to go back and pay them back. But that's the case with any of your creditors. Your debt goes away, but you may choose to make payments to them in the future.
Okay, all right. Let's talk about exemptions. Question is, if I file bankruptcy, can I keep my house or car? I think generally an exemption.
In Minnesota, you can keep your house, and the equity ended up to $360,000, provided you can continue to make the mortgage payments. You know.
Okay.
So yeah, the answer is yeah.
Okay. What other types of assets can you protect?
You can protect around $3,600 of equity in a vehicle. You can protect your retirement account. You can protect equity in your home. A certain amount of cash value in your life insurance. Those are the major areas. With federal exemptions, we have what's called the wild card exemption, which is a blanket exemption that we can apply to any asset to protect it. And so it's an advantage under the federal system if we're able to file under the federal system, because we might be able to protect an ATV or a fishing boat that we couldn't protect under the Minnesota laws.
Okay. Here's a question. It's somewhat complicated. I'm going to try to make sense of it real quickly. From Cloquet, there was a quitclaim deed. I assume this has to do with a purchase of property, a promissory note for $60,000. They put $15,000 down, but then a few payments were made, and then that person, who I assume was purchasing the property, then filed for bankruptcy. Does the seller get? What does the seller get in that situation? Does that make sense?
We can't use that term on the air.
Okay.
I presume what you're saying is they gave the buyer a quitclaim deed and took back a promissory note without a lien attached.
That's what I'm gathering from the call. Yep.
Yeah.
Okay.
So the only thing they're going to get is a claim, I presume, against the buyer for unjust enrichment.
Okay.
But that would be a state law claim and totally outside of bankruptcy, because without the mortgage lien to survive the bankruptcy, the personal obligation is discharged, and they've already given the property away. So
Okay. Well,
it's a bad outcome.
bad outcome.
It's gonna be a
All right.
bad day.
Is there an issue with timing of the bankruptcy in a situation like that? If a person, well, talk about timing issues, I guess. We had talked about a personal injury case earlier. If some exemptions exist before you file the case, but can you explain any of that?
In general, we look at whether you've made a payment over $600 to an unsecured creditor, like a credit card company, a medical institution. If you've made that within 90 days of filing, that money can be requested back into the bankruptcy estate by the trustee. The trustee also looks at transfers and sales of assets that you've made within 2 years of filing to determine if you've made them for fair market value.
Okay. All right. Question, 84-year-old grandmother in September signed a car loan for her granddaughter's boyfriend. He's paid so far part of that, and apparently there's some allegations that he may have lied on the loan papers about his income and his job. Is there anything she can do to get out of that situation? If she's signed on the loan?
No. If he filed a Chapter 13, she would be protected as a co-guarantor. They couldn't pursue her if he filed a Chapter 13. But otherwise, no, they're going to go after, regardless of age.
And regardless, in a situation like this, it isn't necessarily bankruptcy, is it? I mean, there may be a fraud claim or a breach of contract claim that she could make against the boyfriend, theoretically, couldn't she?
I don't think so.
No?
Yeah, I don't
There's
think
no
so.
privity of contract between her and the
I
boyfriend.
suppose. All right, that's between her and the bank, that's right. What happens if you have a debt in one state and then move to another state and file for bankruptcy? Do you file from the original state or anywhere?
That's actually a highly technical question.
It seems pretty simple.
It seems simple, but the bankruptcy laws are very specific as to how long you need to have lived in a state before you can file. It doesn't determine whether the debt from one state or another is discharged. Those debts are discharged. What is critical is which state you're in, because in some states, like we discussed earlier, in Minnesota, I can protect different things than I can protect in Wisconsin, depending how long I've lived in a state. And depending how long I've lived in the last 2 out of 3 years in a state determines which exemptions I can use.
Leave it to lawyers to complicate this.
That's right.
All right.
Congress.
Sorry, it's Congress's problem. Will filing for bankruptcy stop creditors from garnishing my wages?
Absolutely.
Okay.
And all of the wages or the bank account, the money that was taken from the bank accounts within 90 days prior to the bankruptcy will be recovered by the trustee and either paid to the creditors or to the debtor or the debtors if they can exempt the money that was garnished.
Okay. The trustee is basically the person that's technically parceling out what money goes where, essentially.
Yeah, the trustee is, Bridget Bryan is the only trustee left in Duluth now. She's a lawyer. She does an excellent job. And it's her job to make sure that the debtor and the debtor's lawyer have filed the proper schedules and that all of the non-exempt property is accounted for, and she will then liquidate the non-exempt property and distribute the proceeds to the creditors. Now, in some instances, if a debtor or debtors have sufficient income, they can make a deal with the trustee and say, gee, I really want that fishing boat back, and she'll sell it back to him, but her obligation is to make sure that the creditors, get whatever they're entitled to out of the bankruptcy.
So the trustee is an officer of the court. Is the trustee paid by?
Yeah, the trustee is paid in 2 ways. They get a flat fee for each file that they handle.
From whom?
From the bankruptcy court.
Okay.
It's part of the fee that you pay goes to the trustee.
Okay.
They're paid a commission on the amount of property that they recover for the estate. And if she has to do any legal work to recover that property, the bankruptcy court allows her to hire herself as the lawyer for the trustee to do it.
Okay. All right. Yvonne, how is credit affected by filing bankruptcy? And we get a lot of questions and assumptions about what automatically happens if you file for bankruptcy. Can you speak to that?
In general, bankruptcy is on your credit for 10 years. However, does that mean you're never going to get credit? No. I have people who get offered new credit cards within 3 to 6 months after they file. They may pay a higher interest rate than somebody who hasn't filed, but they are offered new credit cards. Also, you'll notice that the local car dealers will advertise that if you have a job, if you show a steady income, you're able to buy a new car. So people think that I'm never going to get credit again. And fortunately or unfortunately, that's not the situation.
It's a function of the market, essentially, isn't it? There isn't any legal prohibition about
No,
giving somebody credit.
No.
And the credit folks understand that people who just file bankruptcy are great credit risks because they don't have any debt. They've got income from their jobs, and they're very likely to be able to repay that particular loan. And they can't file again for 8 years. So
It's interesting.
as strange as it sounds,
Right.
and bankruptcy is it's a morass of paradox, because when you're finished with bankruptcy, you're a good credit risk again.
All right. How long does the process generally take if somebody makes the decision that they want to hire a lawyer and look at bankruptcy?
Usually our office is going to send you out a questionnaire to fill out. As soon as you get that questionnaire back in, we're going to schedule your appointment, usually within the next week. Then you provide all the information. Once you've provided that information, we put it into the computer. You have the meeting with the trustee 30 days after that, and your discharge is 60 days after that. So basically, we're looking at about a 90-day process, depending on how good you are at getting us the paperwork.
Okay. And does a person have to go to court to have a bankruptcy finalized?
There's the meeting of the creditors is scheduled within 30 days after you file the bankruptcy. That is simply a meeting with the trustee, with Bridget, and creditors are invited to attend, although they rarely do. She will ask a series of questions, which we've already asked because they're part of filing the bankruptcy petition and the schedules. After that, if there's any dispute over your exemptions or any dispute of a debt that is claimed to be non-dischargeable because the creditor believes that they were induced by fraud to give you the money, then they will have to go to an actual hearing, a bankruptcy court hearing. The judge will be there. But absent claims of exemptions or non-dischargeability, the bankrupt's client will never see a judge.
Yvonne, can a person stop a foreclosure proceeding by filing bankruptcy?
Yes, they can. The filing, it provides for the automatic stay, which stops the mortgage company from proceeding. They've got a time frame where they then need to refile the documents so that they can continue the foreclosure.
Okay. Here's a gentleman calling in, and this goes to the hunting shack problem. If I co-own a piece of property with another person and that person files bankruptcy, what happens to me? What are my options? What happens to the hunting shack?
The interest in the hunting shack that is owned by the individual filing bankruptcy becomes property of the trustee. The trustee will then determine the value of that interest and will typically sell it to the co-owner or the co-owners. And what happens is it simply becomes a matter of negotiation between the non-filing owner and the trustee as to what the property is worth.
Okay, all right. When a bank forecloses on a house, what are the owner's options to get the house back during the redemption period? First of all, what's a redemption period?
When the bank forecloses on your house, they have a sheriff's sale in Minnesota, and then you have 6 months during which you can rebuy the house. And you have to pay off the entire mortgage plus the costs of the sale. So it's an expensive proposition, but that's when you can buy your home back. In Wisconsin, it's opposite. They have the redemption period, and they have a legal process, and they have the redemption period, and then they have the sheriff's sale.
Okay. Question from a caller: can a credit card judgment against you in conciliation court be dismissed later in a bankruptcy?
Absolutely.
And that's the point. Judgments can be dismissed in bankruptcy, right?
Correct.
Yes.
What if you're just late on a credit card bill and you have there is no legal proceeding that that a credit card company has started against you? You just have an outstanding bill. Is that treated the same way in bankruptcy?
Yeah.
Yes.
Okay.
Whether it's a debt or an actual legal claim.
Okay. Here's a question from a caller: will I have to make my regular monthly payments on the various debts that I have when I file bankruptcy, or I guess while bankruptcy is pending?
That's
No.
called a Chapter 13 bankruptcy.
Okay.
And so in our Chapter 7 bankruptcy, which was a liquidation, we didn't have to make any payments. A Chapter 13, we will typically use, let's say you're behind on your house payments and you've had a change in jobs, so you've got more income. We can use it to catch up that house payment or catch up that car payment to make payments to the trustee so your creditors get paid and you can protect your assets and get your assets back.
Let me just jump in. I read the caller's question a little differently. If you have a secured obligation, such as a mortgage or a car, and you want to keep the house and you want to keep the car after you file bankruptcy, you need to continue paying the mortgage and the car note. A lot of people say, well, I don't have any money. How am I going to afford to file bankruptcy? Well, you don't pay your unsecured creditors. you don't pay your credit card debt because you're going to discharge them anyway.
Okay.
But so, yeah.
All right. Quickly, we only have about a minute left or so. What are the typical scenarios that cause somebody to have to file bankruptcy these days?
The primary reasons that I see people filing bankruptcy are medical debt, loss of job, or divorce.
How prevalent is the medical part of it these days?
Much more prevalent today than it was 5 years ago.
Okay.
I would say 5 years ago, credit card debt drove bankruptcies. Today, it's medical.
Okay. Really quickly, I've heard something about a mass lawsuit, a federal lawsuit having to do with foreclosures. Do we know what that's about, or can you explain that quickly?
Just in general, it's a lawsuit that was done, a class action lawsuit done on the federal level to slap the hands of the banks that violated the foreclosure laws and took advantage of consumers who may have lost their homes.
If somebody gets notice from an entity that talks about their rights, what should they do? Should they call a lawyer, or is this something being taken care of at a federal level? Anybody answer that?
As a general rule, they will receive a check for $500 or more, depending on which bank it was that got their wrists slapped. As part of the information that comes with the check, it will say unequivocally, by cashing the check, you don't give up any of your other rights that you might have under state or federal law to sue the lender, the mortgage company, directly for robo-signing or for a time, these banks were, these national banks were foreclosing, and they were filing false affidavits that the people had abandoned their property so they could get a quicker foreclosure, a quicker redemption period. And so that was part of that lawsuit. The fraudulent stuff the banks were doing to try to recover their property quickly.
This is a pool of money paid by the banks to the
Department of Justice.
Okay. All right. We're going to have to wrap it up. That's all the time we have tonight, but we want to let you know that you can have your questions on tonight's topic or any legal topic answered every Wednesday at noon at the St. Louis County Courthouse through the Volunteer Attorney Program's Ask an Attorney service. Call at 723-4005 to make an appointment. You'll get 10 to 20 minutes with one-on-one with a local volunteer attorney who will be able to answer questions and lead you on the right path to find the additional legal help you may need. This program is free and available to the public regardless of need. Remember, you can watch tonight's program again online at wdse.org or on the Falsani, Balmer, Peterson, Quinn, and Beyer website. Please join us again next week when we answer your questions about automobile injury claims. We'd like to thank our panelists for their expertise here tonight, and thank you for watching. I'm Eric Beyer. Good night.